Yes. So my name's Kay King. As oops, there we go. As Ryan mentioned, from the Administrative Office of the Courts, and what I'm going to talk about today is sort of a general overview of the new minor guardianship statute under 11-130, and it becomes effective January 1st, 2021. Just a little word about our part of the AOC. I'm in a little group called the Office of Guardianship and Elder Services, and that's really a group that works with both professional guardians and puts out training for lay guardians under Title 11. And traditionally, that has been mostly with respect to adults. And so the minor piece is new for our office as well. And just a bit of a disclaimer, it's like this is presentation about what the statute says, but it is not certainly legal advice, and it's certainly, I try to stay away from anything that sounds like an interpretation of, how a statute is going to work or that sort of thing, but just a little disclaimer on that, because that's really outside the scope of what I'm able to do. So this talk has also been structured basically with that child advocate / CASAs in mind. And so that's really going to be sort of the perspective that I'm bringing it through. But I have it arranged in sort of three parts. The first, just kind of talking about what is this giant statute, where does it come from, and sort of how does it fit in the scheme of things. And then you're familiar with non-parental custody actions and what those look like. And so I'm going to spend a little bit of time talking about, what does this look like compared to non-parental custody actions, and then just a little bit at the end about how does this fit in with, particularly in Title 13, as far as what the statute has to say about that and what happened in the bill. So just as a bit of background, this piece that I'm talking about today is part of a giant, but it was a very big statute called the Uniform Guardianship Act that was adopted in 2019, and then there were a lot of amendments to it in 2020, and each bill was a couple hundred pages long. And so there are lots of parts that have to do with adults and all kinds of things that are also part of it, but we're really just going to be focusing on a piece, which is the minor guardianship piece. And so I just want to start out a little bit with kind of doing a framework of like what's happening when with this statute, because that's going to be important. So this giant legislation at the end of the 2020 session basically got a sort of a bifurcated effective date. And so the piece that you're interested in today is minor guardianships under Article 2, and then the rest of it becomes effective in 2022. And the reason I mention that here is that the Title 11 guardianships with respect to property of minors is something that is a little bit more common than Title 11 minor guardianships of the person really. And that piece, the law doesn't actually change until 2022. And so that may not mean a whole lot to you, but again, I'm just trying to give you a little bit of background of where these pieces fit in, because you're going to hear about things like, oh, the UGA, or how about these, if someone has a property settlement or litigation settlement or something like that, that part of the law changes January 1st, 2022. In giving a little bit of background about where this statute comes from, you may have intersected with uniform acts in other aspects of, there's Uniform Parentage Act that was adopted a few years ago. Well, this Uniform Guardianship Act is another one of those. And the genesis kind of is the Uniform Law Commission, which is a bit of an academic kind of group that puts out these kind of roughly model sorts of laws and encourages states to adopt them. But in Washington, as this particular piece Article 2, and I'm going to refer to Article 2 quite a bit because that's the piece that deals with minor guardianship. Through these 2 legislative sessions, the other thing that happened with the Washington law is that Washington repealed non-parental custody. So Washington's version is a little bit of a unique version at this point in time. So giving kind of a general framework to it, I think to understand Title 11 guardianship law, you have to think about the fact that Title 11 is probate and trust law. And so minor guardianships under that law in the past were really kind of about if parents had passed away. And that was the most common sorts of things, other than those sorts of property guardianships I was telling you about. And 2610, as you know, is part of, family law. And so thinking about those 2 orientations will help you kind of understand why the language is what it is and why it looks a little bit different. And then, of course, what you're very familiar with is Title 13 and the 1336 guardianship. And so one of the questions that you would naturally have in mind is like, well, when would you do a 1336 guardianship as opposed to one of these 11130 guardianships? And I think one of the basic points to be aware of, if you this is not already in your lexicon, is that the 1336 guardianship, there has to have been a dependency that was already established. So that's as sort of a basic focus point. That is not required for an 11130 minor guardianship. So the child does not have to be found dependent. It has really nothing to do with necessarily with any dependency action. And I'm going to say this again and again because this is a huge statute. There's a lot of portions that are, particularly with respect to kind of the general provisions, are sort of written with not necessarily tailored to minors. So if you look at some of the Article 1 general provisions that are in the statute, it's written in a way that kind of covers a lot of ground, and it leaves a few questions like, how would this necessarily correspond to a Article 2 minor guardianship? One other thing I'm just going to mention is there's another new creature in this law, which is called a power of attorney for a parent to delegate basically the parent's powers about care, custody, or property of the minor to someone else. This part, this one section, 11-130-145, this actually went into effect already in June of 2020. And this really is not part of guardianship. This is something that might happen instead of guardianship. But I just mention it because it might be something that you come across. And a way to think about this is if you think about the power of attorney in the adult world, where someone does a durable power of attorney, for example, to perhaps their adult son or daughter for medical decisions or for finances. Well, this is kind of another version of that. So I just wanted you to be aware that this kind of creature is out there, because somebody, you may say, well, this parent has delegated their power to someone else. Now, there's a lot of questions that may come up with regard to how that works, and in the midst of parents that are divorced and all kinds of other things. That's kind of beyond the scope of what I'm going to talk about today, but just kind of a heads up that that's one more thing that's out there as part of this really big statute.
Hey, Kate, we had a question come in.
Yes. Uh-huh.
You can do Title 11, though, in dependency, correct? So would it be better to use one over the other?
Well, two things. Yes, I'm going to talk about this a little bit at the end. It is something that is specifically noted as a permanency planning option. The second part, what would be better? That's the exact question that something that I can't give that kind of an answer, because that's kind of inconsistent with my scope. So that might be something you'll talk about or think about, but I can't say what's better. So that's probably a little bit unsatisfactory answer, but I'm afraid I have kind of limitations in terms of answering a question about that sort of thing. So I'm going to talk a little, oh, sorry.
Sorry, follow-up question.
Mhm.
Yeah, maybe this chat thing won't work. If you've got a question, go ahead and just ask it. Melanie, why don't you go ahead?
I was just wondering if will the differences between the two be explained then? If you can't tell us which one is better, in your opinion.
Well, I think that that would probably be yet another presentation, perhaps, because there are differences, and it would be comparing the, what's in 1336, which I don't know how familiar everybody is with those, but I think that's important to do that comparison, but that's beyond the scope of what I did in this presentation, because I'm trying to do a general overview of what this minor guardianship law is about.
All right, I appreciate that. Thank you.
Yeah, and I realize that there is just, it's a lot, but that could be perhaps a follow-up presentation at some point in time.
That would be great.
Okay. So I guess what I'm wondering, Ryan, does it make sense to have a lot of questions going on, or should I go through a little bit more? Because what I'm wondering is if we're going to run into a lot of questions that I might answer with time. I'm not compelled one way or another, but that might just make things a little bit smoother. But we'll just take it as it goes for now.
Presenter's choice. So however you feel more comfortable.
All right. Well, why don't we just keep going as we have been, and then we'll sort of see what happens. So kind of giving a framework idea, looking at the non-parental custody versus this Title 11 minor guardianship. In the past, and this is, we're talking about history, not now, the history, custody is part of non-parental custody, and it says it in the name, but in Title 11, that wasn't necessarily in the law. Now, oftentimes that is what the arrangement was, but it wasn't necessarily dictated by the law that guardian would have custody, and so you might have other variations of that. The other big difference between non-parental custody actions is that it's basically kind of a more usual, this party is coming in asking for custody, and then you have the parents or maybe an existing custodian or guardian, and they're deciding who's going to win that case and have the non-parental custody. Title 11 guardianship is more like, okay, someone is going to petition for this guardianship, and then there may be all these people who have something to say in the course of the case. And we're going to talk a little bit more about that, because this statute requires notice to a whole bunch of folks. And so it's kind of a little bit different creature as a kind of case as well. And if we look at that kind of historical, what the 2610 description of what the custodian would do, they can determine the child's upbringing and education, healthcare, religion, training, unless the court, blah, blah, blah. It's a little bit the same now in this new 1130. But then if you look at the language kind of at the bottom of that, then it's also talking about shall act in the minor's best interests and exercise reasonable care and diligence and prudence. And the reason I bring that up is because the idea of fiduciary duty with a guardian is something that is a really important part of guardianship law in general. Is their fiduciary duty is kind of this higher level of duty under the law, that you have to act in someone's best interests. And then looking at this kind of statutory language about what the duties of a guardian under 11-130 are, it does say that that guardian is a fiduciary, and unless the court limits it otherwise, the guardian has the duties and responsibilities of a parent with respect to support, care, education, and so forth. But then it also talks again about the reasonable care and diligence. So you have responsibilities of a parent and then also the fiduciary duty. And if you look at the other language in the statute talking about the other things that the guardian shall be, it almost sounds a lot more about that kind of slightly more reserved or separated way that a guardian would be, because it talks about the guardian shall be personally acquainted with the minor and maintain sufficient contact. So that's kind of that historical language coming in. But as I said, this version that we have in Washington, that guardian does have the custody. And so, yes, they will be personally acquainted with the minor. The other duties include taking reasonable care of their effects and expending funds, conserving funds, conservatorships. I don't want to spend a lot of time on that, but that's going to be the new way that someone who is appointed to kind of handle a minor's property, if not child support or personal effects, but if a minor has some sort of significant property. Right now, that's called guardianship of the estate. Starting in 2022, that'll be conservatorships. But if a person is an Article 2 minor guardian, then they may need to have a conservator appointed to manage funds. So let's not worry too much about that now, because that is something that's going to apply in some cases, but probably not most cases that are kind of more traditional, what we think of non-parental custody kinds of cases. And again, reporting to the court changes in dwelling or address, etc. Now, this also gets complicated, and I'm going to talk a little bit more about other statutes that affect if someone has custody of a minor and they want to move. You're probably familiar with that statute, but that goes beyond this informing the court of any change. I know this is a lot of information and it's a little bit confusing, but it is, as I said, a statute that is going to be interpreted, and we'll learn more a lot as it gets rolling, because it is a new and very different kind of thing. Now, the other side of the duties is the powers, and again, except as limited by the court order, the guardian of a minor has the parent's powers with respect to support, care, education, health, safety, and welfare. And as that is spelled out, it's like things like get benefits or take custody of the minor. Again, that's the big difference here. It's to take the guardian here would have the ability to take custody of the minor, and then of course has to follow that 2609 process if they want to move out of state, is what it says in this particular statute. But I believe that what most people believe is that the 2609, these provisions about moving with the child apply to any order that affects custody. So even though this part of the statute just talks about moving out of the state, that other statute's going to basically have that minor guardian needing to go through that 2609 process if they want to move out of the school district with the child, with the minor. Other things that you would think, basically, as I said, bring an action to for child support, consent to health care, things like that you would expect. And importantly, the court may authorize a guardian for a minor to consent to adoption of the minor if the minor does not have a parent. But that's something that the court would have to authorize this guardian to do. One area that is of considerable interest and concern, and people are wondering, what happens if I've got a non-parental custody order right now? And what happens to that order? Because we know that 2610 goes away on January 1st, and here's this new law. So what happens to those orders? So basically, a couple of questions to consider here. And the first is, when looking at a non-parental custody order, this statute says if you have one, it remains in effect and it remains operative. However, there is a distinction potentially between a final non-parental custody order and a temporary non-parental custody order. This language doesn't differentiate between a final and a temporary, but if we're looking at it from sort of a legal standpoint, if you have a temporary order and you can't finish the case, somebody doesn't have the authority to finish that case, then your temporary order kind of can't go forward. This is a convoluted, long way of saying right now there's differing viewpoints about what this language means. And so some jurisdictions in the state, like King County, has issued a notice that said, if you have a temporary non-parental custody order, on January 1, your case gets dismissed and it's no longer good. Other jurisdictions read this language differently, and some are saying, well, it says any order, and so what they're planning to do is to allow people with temporary orders in their pending case to basically, they're going to recognize those orders and then allow the person with the temporary orders to convert it to another kind of case. The reason I bring all these issues to you is there's a lot of confusion about this right at the moment. And the reason is it's because there are different interpretations of this language. And so you really have to look at what is happening in the county where the child is located and where that action is going, because different jurisdictions have different answers to this question. Same thing with respect to whether your case just goes away on January 1st and will you have to refile it? Some jurisdictions are saying they're going to do a procedure by their local court rules where someone can do a motion to convert their case to one of these minor guardianship cases. So again, there's not a across the board easy answer to talk about. It depends on the local court. The third piece is, what if you have a final? I've had a final non-parental custody order for 5 years. What happens on January 1st? Well, under the statute, it says if somebody wants to try to modify or terminate that order, then it's subject to these new sets of rules. So that's a whole lot of information I just gave you, and it's a little bit confusing. And if you feel confused, that would be, that means you're probably understanding it, because it's very much local jurisdiction and people coming up with different interpretations of how this kind of transition is going to go forward. Deep breath. Going back to what these kind of, I'm going to call them Article 2 for shorthand, Article 2 minor guardianships. Again, a little bit different than the non-parental custody statute, where the person who wants the custody comes in and says, you know, I want to be appointed custodian. Now, in many cases, in these kinds of actions, the person who wants to be the guardian probably will be the person who's bringing the petition. But it isn't necessarily the case under the way the law is written. And further, there's kind of a hierarchy in the law about who is supposed to be appointed the guardian. And so number one in this kind of priority list is what the parent said. And what it says is a parent in a will or other record. So let's think about that language for a minute. It's talking about a parent in a will or other record. It kind of implicates that the parent is, probably deceased or certainly sort of not around. But since we don't have non-parental custody, now we have parents who may have some other sort of record. Record is a pretty broadly defined term in the statute. And if there's different answers, if one parent says, well, I'm okay with a guardianship, I consent to it, but I want Uncle Bob to be the guardian, and somebody else says, well, I consent, but I want Aunt Mary, then the court between those two will decide who's in the child's best interests. If there isn't anyone nominated by the parents or none of them are in the child's best interests, in this law, kind of like, this will sound familiar, but minors 12 and up have a certain amount of rights, and they can nominate someone that they would like to be their guardian, and that's supposed to be kind of priority 2, again, unless it's not in their best interest. And if none of these nominees are in the child's best interest, then the court shall appoint the guardian that's in the child's best interest. So some of the other parts about Article 2, minor guardianships, letters of office, that's, basically the calling card that people get issued after a guardianship has been established, and that says whether it's full or limited and how long it lasts. Guardian training in this statute, if you want to be a guardian under the statute, you need to go through a training, and our office puts out a training about what does it mean to be a guardian. And we are just in the process of putting together this training to be available by January 1st for people intending to go that.
Perfect.
And the court may waive this training. The other part is in the adult world of guardianship in Title 11, people have to come to court on a regular basis every 1, 2, or 3 years and basically report to the court on what's happening with the adult. It's different in this Article 2 with minors, where there's nothing that's necessarily in place, but the court can order that the guardian has to come back. Also, someone else could ask the court to have some sort of periodic reporting. So the other aspect, which is going to be probably a little bit different than what you're used to in 1336, and this kind of comes from the adult world of guardianship. So, and in the adult world of guardianship, you have what's called full guardianship, and that's when the guardian is making all the decisions, has the power to make all the decisions for a person. And then there's limited guardianships where, for example, someone makes decisions for themselves, but not others. And so that's kind of spelled out with what does that person, what decisions does the guardian get to make, and what decisions might still be with that person. Now, in the Article 2 minor guardianship world, the way this plays out is that the parents, it's going to be a limited guardianship if the parents retain some rights. That's the limited guardianship. And further, the statute says that the court order shall preserve the parents' rights for visitation unless there's a reason why it should be limited. And so if the parents are retaining some rights about decision-making, say, for example, with respect to education or visitation, that's what's going to be a limited guardianship. There's another piece that is probably applicable in kind of the older teenage world, which is the court may also say this minor, because I think this minor is in a position where for developing self-reliance, they should make some decisions about X, Y, or Z thing, and maybe it's something like educational choices or something. The statute doesn't say what that would be necessarily. That's another kind of limited guardianship. And so whether it's full or limited is all about what rights does the guardian have, what powers, and what things are kind of reserved either to the parents or to the minor. As I said before, in terms of what this court process looks like, I want to tell you a little bit about it, because one of the things when you maybe think about, well, what does a 1336 guardianship look like, and what are the steps in that? And that, of course, requires that a dependency that has been established. That's what the statute says. But in this process, there's quite a bit of process in terms of getting this guardianship established. And one of the things is that there's a number of different petitioners who can file the case. So I mentioned a little bit before, it can be, and probably in most cases, the person who wants to be the guardian is also going to be the person who's petitioning, the petitioner. But under the statute, that's not necessarily the same. So it's possible that someone might want to start the court action and nominate someone else to be the guardian. Of course, they would have to agree. You can't appoint someone to be a guardian who's not willing, but those aren't necessarily the same person. Also, the minor can start the guardianship action. There's also a lot of service. It's kind of two categories. The first one is generally personal service, and of course that's with asterisk about, what happens if you can't accomplish personal service. Then there's also sort of a second level of folks who have to get some other sort of notice. It isn't service, but they have to get some notice that lets them know this case is going forward. So the general service part includes the child 12 and over. Now I've got a bunch of asterisks there because this is another thing that is a subject of considerable interest by people, because in general, these minor guardianship actions kind of bring the minor 12 and over into the guardianship court case process. And one of the aspects that people consider, and you probably are very well positioned to have thoughts about this, but whether or not the child 12 and over should have all of the underlying facts and allegations if someone is claiming that a parent is fit, not fit, or has problems, say abuse or substance abuse or sexual abuse, all kinds of things that may or may not be so appropriate or helpful for that minor 12 and over to get specific information about. So I'm going to talk about that a little bit more in another slide, but in general, the child, the minor 12 and over, is to get service of the petition and the notice for hearing and this information. Also, each parent, if there aren't any parents, then the adult nearest kinship, anybody who might have a 2610 order, if there's another one, and anybody else the court says is supposed to get this kind of service. Then, and I showed you that long list of people who may be involved in the case. These kinds of cases, again, sort of the idea is you invite in all kinds of folks who might have spent time with the child or know a lot about the child. So you can see that's a pretty long list. Grandparents, adult siblings, anybody who had primary care and custody of the child for more than 60 days in the last 2 years, same thing, 2 years in the last 5 years. Pretty long list of people who are supposed to get notice. So if you're thinking about what this kind of action considerations that it brings forth is like, wow, that's a lot of notice. That's a lot of people. I've got to try to figure out who are these people and where are they? Particularly if you think about things like maybe you don't know who the grandparents are because maybe one of the parents is not really known or established. The court can waive that requirement of notice to those kind of second tier people. And then there's also a little bit of question under statute, and I'm not going to go too far into that about exactly what constitutes sufficient notice. But the other thing, as people who are very interested in the welfare of a child through these kind of situations, is is this information that's going to minors 12 and older. So basically, the statute gives minors 12 and over the right to receive that information, but the information that describes the specific reasons and factual allegations has to go in a separate document. And then the court can be asked to waive that information be served on that minor. But the minor has the right, if they're 12 and older, to ask the court to see that information in any event. And also, the presumption in the statute is that the child is able to attend and participate in the hearing, basically, unless the court finds that they're really not mature enough or that it would be harmful to them. So that's kind of a case-by-case consideration. But again, the presumption is that the minor is involved. I'm just going to say a few words about court-appointed attorneys. In regular minor guardianship cases, if the parents are indigent and they object, or if the court feels like it's necessary to have an attorney in order for informed consent or otherwise, then the court has to appoint this court-appointed attorney. The court has discretion to appoint, but it's not required in those same situations, even if the parent is not indigent. So I'm not going to go too far into the specifics of all of that, but you'll see it's some attention, it appears, to the constitutional rights of parents in terms of their agreeing or not agreeing to this guardianship. The other new term is something called court visitors, and this gets complicated as well, but it's similar to a guardian ad litem or a CASA in terms of some of the functions, but in the statute, they don't have that same statutory description of saying that they're representing the needs and best interests of the minor. But there are certain times when they are required to be appointed under statute, whereas a guardian ad litem in general is just in the court's discretion. But the primary time that they have to be appointed is if the minor is 12 and older, and if that minor doesn't have an attorney. So here's another really important aspect that you'll want to think about in terms of what does someone have to prove if they're going to do one of these Article 2 guardianships. So there's kind of the first consideration that it's in the child's best interests. And then it's basically one of three things. If both parents agree, if parents' rights are terminated, or, and here's where it's going to be new interpretations coming out because it's new language, no parent of the child is willing or able to exercise parenting functions as defined in a specific section of the law. And let me move my little icon there. It's basically the 2609 definitions of parenting functions. So that's a new and different standard. And so there isn't case law under that. And so that will be something that will that statutory language interpreted in these guardianships. A couple other just quick things similar to non-parental custody. As I said, the parents may retain some of those rights, like visitation schedules. You're supposed to have criminal background checks and CPS background checks. I'm going to put a little asterisk here, which is the statute right now says these things have to be done for the petitioner and adult members of the petitioner's household. Now, of course, it's the guardian, the person who's going to have custody of the child, who it's going to be important to have that information. In most cases, that's going to be the same person, but there is that sort of statutory bit of a glitch there where it's talking about the petitioner, but it's really the guardian that you want those background checks on. Support and insurance can be requested, and then there's language brought over that if there's a separate cause of action about a protection order, anti-harassment order, those become associated with this case. Just like in dependency, ICWA applies, and so the kind of notice and considerations, again, that's a whole nother CLE on its own, and you know about ICWA processes from working in the dependency world, but that is part of this statute as well. So here's the other interesting part of this statute, and that is when do these minor guardianships end? What are the circumstances? And there's kind of the statutory list of adoption, emancipation, attainment of majority. In other words, of course, when the kid's 18, it would naturally end by its terms. Or, and here's where, again, it's a new statutory standard. And basically it says that guardianship can end when the reason for the guardianship no longer is true. So if we look back to those reasons where it's in the child's best interest and either the parents agreed the rights were terminated, or no parent is willing and able to perform parenting functions. So if that reason has gone away, then this Article 2 guardianship ends unless the court finds two things: that it's harmful to the minor and the minor's interest in the guardianship basically outweighs the parent's rights. So again, if we look at these standards and what they mean, because the language is a little bit different and we have the issues of constitutional rights of parents, I imagine we'll see in cases how this is applied and what we have to learn about that. I'm just going to say a quick word about two other types of minor guardianships under this statute. There is a provision for something called emergency guardianship, and we don't really have enough time. I'm just going to check my timer because I do want to leave some time for questions. Basically, emergency guardianships are meant to be temporary creatures. They have a lifespan of 60 days. They can be extended up to another 60 days. So by their terms, it's at most 120 days. But if someone files a regular or a standby guardianship petition, then the court can extend that emergency guardianship. But it's very different than temporary orders in a non-parental custody action because it's time limited unless someone starts that other action. It also has a different legal standard to establish it. And it's basically if there's going to be a threat of harm to this minor's safety and welfare, and there doesn't appear to be anybody else able to act in the circumstances. So that's emergency guardianship. It's got a faster time frames, different procedures. There's an ex parte mechanism within it, but that's a very time limited thing. So that probably in the dependency world is not going to mean so much. The other creature that I'm just going to mention is what's called a standby guardianship. And I think the best shorthand for thinking about this is that's kind of a parental planning tool. So if a parent knows that at some point within 2 years, they're not going to be able to parent, and that might be something like if someone, has a very severe illness that they're concerned that they won't be able to function as a parent or survive, or they think they might be deported, or any number of reasons where the parent thinks they probably won't be there, but want to set up something that, for the future when that event happens. So I'm just going to mention a few words about in general, how this, what happened in 6287, and which is the second of the bills. But in this UGA, basically, the court has to check and see whether there's another case regarding the minor pending. And so then that has to be considered. And so if there's a dependency that's already started, then you can't have, or you shouldn't have by statute, the guardianship court considering a case without considering that there's a dependency case going on or some other sort of case that affects the minor. 1334 was amended in the 2020 amendments to this act to make 11130 minor guardianship an option in permanency planning. And I put a list here of sections of 1334 that were amended in 6287. And I haven't checked in for a few weeks, but I know when I checked about a month ago, these amendments to 1334 were not up on the Washington legislative site yet. So that's something that is important to be aware of. And I'm putting just a few little clips here from it. And basically it adds a guardianship definition that includes the 11130. And then it also, in one section, these aren't all the sections, talking about permanency plan, identifying outcomes as a primary goal. And again, it's just references, instead of where you would have seen non-parental custody, it's referencing this minor guardianship. So I'm going to say thanks for listening. I know there's probably a lot of questions and I will answer what I can. And I know that was really a boatload of information, but at least it's sort of an introduction to the topic, and we'll all, I'm sure, be learning more about it as time goes on. So thank you for your attention, and I'll be happy to look at questions. I see someone's asking if we can get a copy of the slides. Yes, I will make a PDF of the slides and send them to Ryan after the. And are there other questions that were in the chat, Ryan, or?
That was the big one. Can we get a copy of the slides? Yeah. Anyone else?
There were other questions. There's a lot more questions on the chat. Like, let's see. Someone, like I asked, should the conservator put the funds in a separate account? Like if they're running the child's money, and then someone else asked, does anyone else think people may use 12 and up instead of chins? And I didn't hear that one be asked, be answered.
Well, the questions about the conservatorship, when we're talking about conservatorship, I want to make 2 points. One is those conservatorship things become effective in 2022. Right now there is existing, it's called guardianship of the estate. And so if there is those sorts of funds, there are rules in the statute and in accordance with fiduciary duty. And that's part of, remember I talked about the lay guardian training? There are certain rules that people need to follow, and they have to report to the court. And so there is more specificity about that. It's not like here, you just have the money and you can do what you want. There's some rules around that. But right now that's still under the existing law and the existing 1188 and 1192 statutes. With respect to the question about chins, you know, it's a good question. I don't know how these things are going to be used necessarily, and whether or not this is another option. I've heard that same question raised, and I guess we'll see what happens. I'm sure a lot of much brighter minds than mine will be thinking about ways how the statute, what circumstances under which it'll come into play.
Anyone else? think we're good, Kay. So if you can't, just send me that PowerPoint, and anything else that you wanted to add?
I don't think at this point in time. I think really the big take homes are from the child advocate point of view, is that this was 1330 was changed to instead of non-parental custody, this kind of guardianship coming in. But think about what it, I think from a child welfare point of view, it's going to be interesting to see in terms of what that standard looks like, to have a guardian appointed, how that intersects with current case law about parents' constitutional rights, which there's quite a bit of case law at both the obviously the federal level and the state level, and then also knowing that in terms of thinking about permanency planning options, the standard for when that guardianship can end. I think there's some very interesting issues to think about and how this is going to look going forward. I know that sounds super vague, but what I'm trying to say is it's a big law and a big change, and I think we'll all know a lot more soon. But I can't predict the future, and it's inappropriate for me to say so. I can really just talk about what's in the statute in terms of language, because until we have the case law and how it's really interpreted and how it's used, that's really all that I can say. As we learn more, I certainly will be doing, more presentations, but right now that's what I know is what is in the words of the statute, and people are certainly trying to figure out what it all means. As I said, many minds and many much brighter minds than mine. So I do thank you for your attention, and I definitely will send the PDF.
Yeah, and if you do, as this progresses and we learn a little bit more, if you do have an updated presentation, we'd be happy to have you back.
Okay, thank
just
you.
let me know. All right.
All right.
All right, everyone. Thank you so much.